Good morning, welcome to the Editorial Edge. My name is Bhuvan. As in the next, say, 45-50 minutes, we will take a look at multiple topics that have been in the news. All right. First, we will begin with the changes that have been proposed by the Home Minister to what are probably the fundamental three acts when it comes to, say, the justice delivery system in our country. That is IPC, CrPC, and Evidence Act. So first, before obviously going into the details of what the changes are, because again, please realize that these three bills that these three procedures, codes that I just told you about, they are sought to be amended, and the changes right now, the first draft has been released, it has been referred to the Parliamentary Standing Committee. So the changes will be obviously concretized in the days to come. But as students of UPSC, it's imperative for us to first take a look at what IPC is, what CrPC is, what Evidence Act is. All right. So that's going to be our first agenda. Thereafter, we'll take a look at a bird. Okay. Bulbul, Sai Krishna, good morning, welcome guys. Second, we'll take a look at the Indian eagle owl. Okay. Now that has been released as a distinct subspecies of owl. Up until now, it was considered as a part of the Eurasian eagle owl. So we'll take a look at this particular species. Okay. Environment should remain a focus area for us. Third, we'll take a look at the recent changes that have been proposed to the name of Kerala. You know, the Kerala State Assembly has gone ahead and passed a resolution to that effect. So I think it's imperative for us to quickly revisit Article 3. Okay. What exactly does Article 3 speak about? Okay. So that's going to be our agenda. First, obviously, we'll take an extensive look at the three IPC, CrPC and Evidence Act. But before that, quickly go ahead and scan this if you want to connect with me on Instagram. All right. For any doubts, any particular questions, resolutions, whatever you may seek my advice on. And second, here is my Telegram channel where you'll find the PDF of this particular lecture uploaded at noon. Okay. Whatever questions that are introduced to you here, you will shoot your answers to me, the mains related questions. You will shoot your answers to me at this particular email ID. And the questions that I have for you. So I have multiple MCQs in this course of the next 45-50 minutes, the answers for which you will leave for me in the comment box. Okay. Because what we seek to do is outcome based learning. So those students who answer correctly, they will figure their names will be figured in the next class, in the class on Monday, Tuesday, whenever it is. Okay. All right. Let's take a look at the questions from the last class though first. So first, in the last class, we discussed and took an extensive look at Assam Rifles. Okay. It has been in the news, obviously because of the situation in the northeast in Manipur. So we took a look at Assam Rifles, and so let's look at this question. Its primary responsibility is to guard the Indo-Myanmar border. Officers of both Army and the MHA is the Home Affairs Ministry, serve in it. Which of the above are correct in the context of, well, I have asked you in the context of Assam Regiment. Okay, many of you got this incorrect. And even though I had mentioned in the class that please be a little careful. You know, Assam Rifles is a paramilitary organization. Assam Regiment is an arm, is a wing, is a regiment of the Indian Army, much like say Gorkha Regiment or Jat Regiment or Mahar Regiment or Punjab Regiment. Okay. So in this case, because this is a unit of the Indian Army, well, obviously you do not have individuals from the MHA serving in it. And obviously its role is not just for the Indo-Myanmar border, which means in this case, the answer to this is none of the above. All right. Let's go to the next question. SSB. Now, the operating agencies and where do they operate? Okay. So, SSB does operate on the India-Nepal border. BSF on the India-Bangladesh plus Pakistan border. All right. You're looking at ITBP, obviously not on the Indo-Bhutan border. In fact, ITBP is for China. Whereas the Indo-Bhutan border, after you see the recent, say, developments insofar as the Chinese presence in Bhutan is concerned, you see now that Indo-Bhutan border is being taken care of by the SSB, and in the Siliguri corridor, this chicken's neck that we often talk about when it comes to say India's security structure, you know, its weakness, our weakness of sorts, this Siliguri corridor, well, there you find the presence of BSF, ITBP and SSB. All right. But just purely from the theoretical perspective, it is SSB that is manning the borders with Bhutan. All right. And Assam Rifles, AR, the Indo-Myanmar border. So the correctly matched here being A, B and D. All right, let's go forward. The next question, NDRF, National Disaster Response Force. Okay. Where does it get its officers from? Where does it get its men and material from? Well, what you find is that it has officers on deputation from all paramilitary forces, obviously except NSG. This is for a specific purpose. It's a special ops division, a strategic force. It is not a part of the NDRF. Good morning, Shubhankar. Jai Hind. Welcome, welcome. Thanks for joining, guys. Okay. Next, the operational control of NSG and SPG. Now, SPG is the Special Protection Group, which gives proximity security to VVIPs. Right now, in 2023, you find that the Prime Minister is the only SPG protectee. Okay. Earlier, you had other individuals. Now, that has been withdrawn. As of now, you only find that the Prime Minister is protected by the SPG, and it reports directly to the Prime Minister's office, in fact, under Cabinet Secretariat. All right. So, SPG is not with the Ministry of Home Affairs. No. In fact, it is with the Prime Minister's office, ideally under the CabSec. Okay. NSG Training Center is in Manesar. Okay. It's not very far from Gurgaon here. So, the correct options here being A and D. All right. Please realize NSG's operational control is with the Ministry of Home Affairs, much like the other paramilitary forces. All right. Okay. Next. So, well, there's something gone wrong with the alignment here, but which of these are part of the Amazon River Basin? So, straight away, you'll find it's Brazil, Bolivia, Colombia. All right. Then you find Venezuela. All right. You find Suriname, Guyana. All right. I think it's a group of 8 nations. Is it, guys? So, 1, 2, 3, 4, 5, 6. What am I missing now here? Let's see. Oh, you have Peru also, correct? All right. And you do not find Chile and Uruguay. Okay. In fact, Chile is not a part of the Amazon River Basin. Uruguay is obviously not a part. Argentina is not a part. Remember that the Amazon River Basin is to do with the states that are in the northern part of the South American continent. Okay. So, if you know your mapping, you will know that most of these countries, in fact, all of these countries, are towards the northern part of the South American continent. All right. Amazon rainforests comprise moist broadleaf tropical forests, correct? Machu Picchu, you must have seen a documentary on it or read up about it or even heard of it. Okay. It's the land of the Incas, the lost tribes of Incas is what it is known for. And what you find is that it is not in fact in North Amazonia, but in fact in Southern Amazonia. Okay, it's a part of the fringe area of the Amazon forests. So, you find it towards the southern side of the Amazon basin. And Suriname, which has been in the news recently, okay, you have had the Prime Minister of Suriname come and visit us, and on Pravasi Bharatiya Divas also, the person Chandrika Prasad Santokhi, I believe is the name, was the chief guest on Pravasi Bharatiya Divas also. So, Suriname is in fact a part of the Amazon Cooperation Treaty Organization, the ACTO, which is in fact working for 2 particular agencies. They just had the Amazon Summit right now. All right. The Amazon Summit also leading to the Belém Declaration, which we discussed in the last class, to do with conservation of the Amazon forests, wherein they could not agree on a common goal for deforestation, for stopping deforestation. Ecuador also, right? Correct. Subhankar. Yes, I missed it. Ecuador. Okay. So, in the Belém Declaration, they could not come to a common consensus regarding, say, stopping deforestation in the Amazon forest. Now, why? We discussed in the last class that individual states have individual priorities and motivations. Oil drilling is a problem there. And so, you find that the host nation Brazil did not agree to the common goals that were put forward. So, now what you find is that all of these 8 Amazon basin countries have individual targets of reducing deforestation, much leading to the speculation that, well, Amazon will see further deforestation in the days and years to come. Take it? All right. So, incorrect statements here being obviously B. Okay. B is the incorrect statement here. Next, Formosa Street, Taiwan separates Taiwan from China. Correct or incorrect, guys? You will let me know. And the Taipei Economic and Cultural Center you find is in Delhi plus Chennai. Okay. It's also in Chennai. And they together serve the entire Indo-Sri Lankan region. Okay. It's a mechanism of cooperation between Taiwan and, say, the Indian subcontinent, loosely put. Okay. and you find that right now the areas of convergence, except say technology and the usual suspects, is also to do a lot with say cultural integration and realization of say social and cultural goals. Okay, so what you find here is that this is incorrect. Is this one correct, guys? Can you answer me in the comment box very quickly? Is the first one correct? Okay, yes. So the incorrect statements here being B only. Alright, let's go forward. RTE Act does not apply on say religious educational institutions is correct. In fact, it is one of the primary criticisms of RTE that it is not inclusive in say having subsumed all sorts of educational institutions. Okay, so this is again correct. Annual State of Education Report, also known as the ASER report, which we discussed again in the last class, is not published by the Government of India, but in fact published by a non-governmental organization by the name of Pratham. Okay, so this does the work of say assessing educational outcomes and infrastructure across rural and urban areas, and so thus you find that this is not published by the Ministry of Education. In fact, it is a review of the policies and the whole program that is done by the Ministry of Education. So this is how you see, whenever you talk about say NGOs acting as say a mirror to the government, holding government accountable, this is one such instance. A review of India's educational outcomes, educational infrastructure, goals is done by an NGO called Pratham. Okay. Originally, education in India was included as a state subject is correct. In fact, you find that in the 42nd Amendment Act, okay, which was in the year 76, I believe, this is when it gets transferred to the concurrent list. All right. So the mini constitution, as we know it, was the one that finally transferred education into the concurrent list, making it the responsibility of both the union and the states. Okay. So the incorrect statements here being B and, well, is it D? Okay, B and D. All right. So these are my individuals who took time out, the effort to go ahead and answer these questions. They may have got one or two incorrect. Most of them, in fact, got the first one incorrect, the Assam Rifles versus Assam Regiment one. But my congratulations to these guys, because what I see is consistency coming out of most of these names. You know, these are repetitive, repeat names that figure on this program, on this 1 hour intensive session. And so to the rest, you know, even if you don't want your name figured here, it's fine. You know, some of you might be private individuals. Go ahead and answer the questions. You can answer them for me on my Instagram channel, if you wouldn't like to post it on YouTube, or send me an email with your answers. Regardless of wherever you choose to communicate with me, go ahead and engage with these questions. They will seek to concretize your understanding of the particular topic. All right, okay, let's go forward. Now we have the first topic of the day, and so the Home Minister yesterday introduced 3 particular bills in the Parliament. Okay, the 3 seek to amend the fundamental basis of criminal justice or justice delivery in our country. Okay, so what is justice delivery? So, you know, the act of giving a fair and a just resolution to a grievance or a problem. Okay, that is justice delivery by a foreign individual. So now what you find that the 3 bills introduced, the Bharatiya Nyaya Sanhita, which will replace the IPC, the Bharatiya Nagrik Suraksha Sanhita, which will replace the CrPC, and the Bharatiya Sakshya Bill, which will replace the Evidence Act of 1972. These are in the Lok Sabha right now, introduced in the Lok Sabha firstly. Okay. Now first understand, before we go into what the changes are, because I see many students getting worried about the changes that are being proposed. Please understand, this is just the first draft. Okay. The bill has gone to a parliamentary standing committee, which will give its recommendation. There is a lot of deliberation to happen before it becomes an act, which is why right now our focus should be on understanding about the changes to the document that is trying to make, say IPC, CrPC, Evidence Act. Okay. So that's what we'll seek to do in this class. But before that, okay, before we get into say this whole differences between individual IPC, CrPC, Evidence Act, first let's understand how justice delivery works. Okay. So you must have seen, most of you, or those who will be watching this say in the times to come, in the hours to come or thereafter. So many of you might be seeing these sitcoms, no? Or these say TV series, say Suits. See, if you have seen Suits on Netflix, you will find that say the courts in America work in a different manner. Okay. Or if you have been seeing say regularly these crime and justice shows, you will see that courts work in different manners. Justice is delivered in a different manner and is not uniform. Okay. Now, what do I mean by that? So, essentially, the justice delivery system, okay, when you talk about justice delivery, you are looking at two basic forms of, say, justice delivery that is practiced today. Okay. One is the adversary system. Now, pay attention here because this will help you frame a good mains answer also. Okay. One is an adversary system, and then the other one that you find is an inquisitorial system. Now, we'll understand quickly the difference between the two, because only then we'll understand what is happening, why is it happening. Okay. So, now the adversary system. The English word adversary means two or more, say, opponents. The name gives the whole meaning away. In adversary system, the focus is on, say, a plaintiff, a defendant. What you are seeing is that the lawyers, say the prosecution lawyer and the defense lawyer, they are the primary focus. In fact, if you were to study, I was just reading about it, the term that is used here is the struggle between the two lawyers brings to light the truth. Alright, this is what happens here. You have two lawyers who go ahead, one is in charge of, say, prosecution, the other one is in charge of defense. Okay, and then the court, the justice delivery mechanism is designed in a way in which their arguments and counter arguments, presentation of facts, negation of facts, cross-examining witnesses, all of that process, that churning that happens, and then the whole system is hopeful. In fact, the system aims that because of the churning that happens, eventually the truth shall reveal itself. Okay. Now, this adversary system is formed in common law countries. Okay. Now, what are the common law countries? So, you find that the common law countries, such as, say, you are looking at the Commonwealth, okay, which means we are a part of this. All right. You are looking at US, UK. These countries follow the adversarial system of justice delivery. Okay. Now, the next one is the inquisitorial system, which is again, here the problem is, in fact, the whole goal is that the judge is an active participant in the process. Now, what do I mean by this? So, in this case, example, our courts, a judge is supposed to be this absolutely unbiased person who will consider whatever facts is presented in front of him or her, the evidence that is presented, and the arguments and the counter arguments that follow. So, a judge here is in fact an ancillary or entity. Whereas in an inquisitorial system, a judge is a part of this whole process. The judge can in fact be considered to be the one who drives the whole investigation also. Okay. So, here the judge is the center court. You don't find the lawyers gaining relevance here. Whereas in the adversarial system, the judge does not have much relevance. It's the lawyers who carry out the whole show. Okay. So, in the inquisitorial system, you find that the civil law is followed, the civil law countries. Okay. So, for example, you have countries like, say, former French colonies, Dutch colonies, Portuguese colonies, or even Portugal themselves. All of these countries and their colonies and their protectorates, they follow the inquisitorial system. Okay. Now, there are some other differences also that you ought to know about here. Okay. So, for example, if you consider, say, the impact of precedents, judicial precedents, what you find is that judicial precedents, okay, just make a note of this so that you are able to, obviously I'll share this whole thing with you. Take a look at this. The judicial precedents is a major part of the adversarial system. Think of our Indian courts. We have precedents that are set up by, say, the Supreme Court, the High Court, and those have relevance, say, in the discharge of justice, say 5 years down the line, 10 years down the line. Today we talk about Keshavananda Bharti case. A precedent has been set. Do you realize? So, that is a part of the adversarial system. Whereas, in an inquisitorial system, the formula of precedence does not apply. What the whole point here is that the judge will take it on the matters, on the contemporary relevance of facts. Historical relevance does not matter. Precedence does not matter. Okay. Similarly, you are also looking at the investigation procedure being different. Alright. Are you guys able to get it? Let me know in the chat with a yes first. Let me know very quickly that you are understanding the difference between adversarial and inquisitorial first. Let me know very quickly in the chat if you're watching this live. Okay. Fine. Let me know very quickly, guys. Chop chop. So in the investigation procedure now, think of this way. How does investigation happen in our case? You have, say, the police that goes and gathers evidence and tries to build a case so as the alleged person, the conspirator or the perpetrator can be prosecuted. Okay. But what you find is that in the inquisitorial system, say, think of the Department of Justice in the United States. Think of that way. Obviously, United States belongs here, but think of it that way. That you have a particular organization that will drive the case, and in that inquisitorial system, suppose, say, I am a part of the organization that has sued someone. Okay. Now, I can go ahead and ask the police that, you know what, get me evidence that corroborates this fact. Get me this evidence so that I can go ahead and prosecute the person. You know. So there again you see that the lawyers are not the one who are running the show. Okay. It's the judge plus the government. Okay. So this is what you find here. That precedence is not here. You also find that evidence, it's completely different. The way in manner in which it is admitted. Gathering of evidence plus admitting of evidence. So for example, in our case, you need to give prior notice to the court if you want to, say, introduce an evidence into the trial. Do you know that? So that even the opposing party also has access to that evidence. That is not required in an inquisitorial system. Okay. Here, in fact, the evidence can be presented at the last moment, and it is upon the judge's discretion whether to admit it or reject it. समझ में आ रहा है आपको? So these are the changes, the basic changes. Again, there are many other changes. Say the role of judge. First and foremost, the role of judge here is not in the limelight. Okay, the judge is supposed to be an unbiased participant in the court process, whereas here the judge is the hero. The judge is the one who drives the whole investigation forward. Okay, several other changes, minor differences are there, but then this is the fundamental theory. Now, India follows obviously the adversarial system. Okay. Now, which is why you find that one of the primary recommendations of this committee, okay, the Malimath Committee, one of the primary recommendations of this committee was that India should transition from this to this. Now you know the story of, say, criminal justice delivery in India. Okay. After you have understood adversarial versus inquisitorial, now you will understand why the committee wants us to go from adversarial to inquisitorial. Okay. Why again? Because here what you find is that the victim, okay, the victim is not a part of the process, the justice delivery process. For example, you went ahead, a person A went ahead and murdered person B. Okay. Person B is dead now. Person B's families are there. They are not a part of the trial process. What you find is it's A versus the Union of India. Okay. So again, it's not inclusive. Whereas what you find there is that the victim is an inherent part of the process. That the victim also has a side to put. Do you realize? That is considered in the inquisitorial system. Which is why the Malimath Committee suggested that go ahead, India should adopt and transition from an adversarial system to an inquisitorial system. Now that you have gathered the fundamental blocks of criminal justice system delivery in India, now let's go ahead and take a look at what exactly is the crux of the matter. Okay, first, what is criminal justice system? The process of arresting, followed by inquiry, and then finding proof. After you find proof, you go ahead and prosecute the person, which means you will file the charges. Okay. The person whom you are trying to go ahead and, say, prosecute has a right of defense, has a right of, say, saying the version of the person also. So you find that a defense is formed. Then trials are held. Finally, sentences are delivered. Is that not the process of criminal justice? So now that just you understood this only. Adversarial system versus inquisitorial system. Okay. two adept advocates go toe to toe. Eventually, it is about lawyer 1 versus lawyer 2, which is why you find that lawyers have also different fees. Why? Because their ability to convince the court comes from rationality, from the power of arguments. It's not just say you go ahead and say present facts and then hope that the judge understands your point of view. No, you have to go ahead and build a case for yourself, which is why individual merit counts, which means that say the process of delivery of justice is co-dependent on the type of lawyer you hire. So if you hire a lawyer, suppose who's a novice, versus suppose someone like Ram Jethmalani, how is that going to figure out in the court? Which is why the Malimath Committee, again, many recommendations were there. All of that were centered around this, that India should transition from adversarial to inquisitorial. Okay, so adversarial, common law countries such as United States, Canada and the Commonwealth. Most of us follow the adversarial system. Whereas the inquisitorial system, the judges evaluate and express concerns in this system. Okay, so the process's efficiency is to do with the judge's capacity, not the lawyer's capacity. The judge is the hero here. Okay, so you find wherever it is used, former colonies of Dutch, German, Spanish, their protectorates, that is still in use there. Okay, so now that India follows the adversarial system of justice delivery, now let's look at the IPC. What is the IPC? So, what is the penal code first? The Indian Penal Code, IPC. Penal means to penalize. IPC deals with the whole manner in which you are going to go ahead and penalize someone for a problem that they have created. Okay, so it defines or mentions firstly crimes and offences which are punishable. If you want to go ahead and prosecute, if a crime has been committed in a society, first you need to define the crime. Okay, so that is the whole process here. What different types of crimes? Say simple, from say going ahead and saying a bad word to someone in public, to having see the most gruesome of rapes and murders. Okay, all of that, you think of the crime finds mention in the IPC. Alright, so the Indian Penal Code, the main criminal code of the country, includes all the criminal offences, including related to human body, property, conspiracy, all of that. Okay, and anyone found guilty, you will be convicted. In fact, you will be charged under IPC particular sections. So for example, up until now, if you committed a murder, you will find that the police department would charge you under IPC 302, which means that straight away the murder charges are being levelled against you. So under the adversarial system, your lawyer will go ahead and convince the court that okay, murder was probably not premeditated. It was probably a self-defense or whatever dalil or arguments the person may have. Okay. So now the first draft of this made by Thomas Macaulay. What else did this person do? Very important name. In fact, you find that this person's name is often used in a condescending manner. Okay. So who was Thomas Macaulay? Very quickly, let me know in the chat. You should be aware of these individuals. So the draft IPC, which was published in say 1860s. Okay. What you find is that this was an amalgamation of the law of England plus the Napoleonic Code and the Louisiana Code. So all the best, the mixed bag of the three operative codes that time. Okay. So you had the English code that was in operation in England, Napoleonic Code, which was a code of say justice delivery that had come through since Napoleon's time, in operation in certain parts of Europe. And then you had the Louisiana Code, which was in operation for justice delivery in United States. So it cherry picked the best parts of each of it and made the Indian Penal Code. Okay. Now once this comes into operation, what you find is it replaces the Mohammedan law. Up until then, criminal justice delivery would be governed under the Mohammedan law. Okay. Now what you find is that at that time, say in 1860, you are finding say India was again a mix of EIC plus princely states, which means that the areas that the EIC controlled or governed, they quickly adopted the IPC. Okay, or they had the Mohammedan law previously before that. However, in the princely states, they had their own justice delivery system according to local traditions or the rules that were enforced by the princely state. Clear? Correct, Shubhankar. Good to see that you identify that very quickly. The rest of the class too. Take active participation. You learn a lot. Okay. So, Mohammedan law was replaced, but the princely states had their own criminal justice law that time. Alright. Let's look at the CrPC now. So now you know the definitions, definitions of various types of say crimes that are to be committed. What does the CrPC do? The Code of Criminal Procedure, which means how are you going to go ahead and say understand and carry out that particular prosecution. So for example, there's two things that you need to understand here. One is substantive, okay? One is substantive law versus procedural law. Now what does these two mean? Understand in a simple language, okay? The polity books will complicate this for you. Understand it in a simple language. Substantive law is essentially related to how you should behave in a society, okay? That these are the rules, the regulations, the guidelines that as a citizen you are expected to follow, okay? And if you break them, then you will be say prosecuted by the state. So that method of prosecution is called procedural law. So which means that IPC becomes a substantive law, okay? It defines the various transgressions that a citizen may or may not do in a particular society, in a country, in a legal system. Whereas the procedural law states that if you commit those violations, if those transgressions are committed by you, this is the manner in which you will be prosecuted or held accountable. Understand that? So procedural law is the CrPC. Okay, make that distinction in your head right now. Substantive is IPC, to do with the do's and don'ts. And if you commit a problem, if you commit an issue, then you will be prosecuted under CrPC. Okay, that the method is CrPC. So the fundamental set of laws governing the administration of substantive criminal law. Look at this. It is essentially to do with the administration of the IPC. How are you going to go ahead and convict a person under IPC 302? Well, there are certain rules and guidelines that are defined under CrPC. Okay, so CrPC establishes the necessary machinery for apprehending offenders, investigating criminal cases, putting them before courts, and finally punishing. Now what is the basic? So what is needed for a good, efficient justice delivery system? Think of it in your head. The ideal scenario. Number one, it should be a fair trial, that it should reflect the truth eventually after the churning that happens, regardless of whether it is an adversarial system or an inquisitorial system. After the churning that happens, the truth should emerge. Okay. At the same time, the truth should emerge timely, because again, justice delayed is justice denied. So the truth should emerge and should emerge timely, and this process should be accessible to all, inclusive. You can't have that only the rich have access to justice delivery. It should be equally accessible to the rich, the underprivileged, the person who is even in the deep forests. If his or her rights are say violated, well, go ahead. Fair delivery of justice has to be ensured there. So the fundamental basis of CrPC is exactly that. Okay. So it also establishes the hierarchy of criminal courts, right from say magistrate level class court, class 1 courts, up until say the highest level. Okay, the whole procedure is laid down. What you find is say the armed forces, court martial, okay. Court martial and all are included in this, by the way. Okay, the Indian Penal Code 1867, it was passed by the British Parliament, CrPC in 1882, and what you find is the Evidence Act eventually came much later. Okay, we'll take a look at that also. Clear? Are you clear here, guys? If this is clear, then let's go at the Evidence Act now. So now you know that the whole process of justice delivery is that it lies on evidences or facts. Okay. What facts are admissible, what facts are not admissible. Okay. Because again, evidence that is gathered, the procedure in which an evidence is gathered also matters. Okay. Just having the evidence in front of the court is not important, which is why you find that if the police wants to go ahead and say wire your phone or say tap your phone, they need a particular permission from the Home Secretary of the state. However, if that procedure is not followed, if the police gets a chat of your phone, you are doing in some nefarious activities, okay, anti-India activities. Even then, if they have not taken prior sanction of the Union Home Secretary, that evidence cannot be admitted in court. Which means the manner in which you obtain the evidence also matters. Just the mere presentation of the evidence in front of the court is not enough. Okay. So which is why you have a whole set of rules and guidelines that will regulate what kind of evidence should be admissible, what is the manner in which you are supposed to gather those evidences, and what is the manner in which certain evidences may not be admitted. Clear? All of this is under the Indian Evidence Act. So this person, Sir Fitz James Stephen, he was the person who is credited. He was in fact an eminent British jurist. Okay, he was a jurist of his time. So he is credited with this particular document. Okay, so it applies to all judicial proceedings. Make a note of this, including the court-martial. So even you find that the army officers say when they are court-martialed, the evidence that is gathered has to follow the norms and guidelines of the Indian Evidence Act. Okay. Now, what you also find is that it is not applicable on certain arbitrations and affidavits. Okay. Therein the manner is different. Arbitrations are what? So negotiations and understandings between corporations or particular business organizations or entities. In that manner, the Indian Evidence Act does not specify any particular guidelines or rules. Okay. That is governed by a separate structure altogether. Clear? So after independence, what you find is that the Evidence Act has been used by India and Pakistan. Pakistan repealed it in 84. Currently, Evidence Act is in use in India and Bangladesh. The IPC on the other hand, guys, what you find is that it is in use in India, in Pakistan, in Sri Lanka, in Bangladesh, in Southeast Asia. You find many countries that rely on IPC. In fact, just amended to their local conditions, their local requirements. But the fundamental document which governs criminal justice delivery in these countries also is coming out of the IPC. Okay. So you realize this has become like a very fundamental document for a large area of segment of population in our part of the world. So you need to know about IPC, CrPC, Evidence Act. Good morning, Deepak. Welcome. All right. Now let's look at this very important slide, and this will just clear the whole thing for you. Okay, the 4 questions that you should consider for Evidence Act. Look at the questions. What is the evidence given of? Okay, whether it is facts in issue or relevant facts. Is it topical or is it relevant? You first need to understand that. Okay. Number 2, how the evidence are given. For example, is it oral or is it documentary? That is again considered before the court. Okay, oral evidence is only registered if it is in front of a magistrate or a person appointed by the court. Do you realize that? Documentary evidence again needs to be countersigned, stamped, all of that procedure is there. Okay, you're also looking at on whom does the burden of proof lie. There is 2 things, onus of proof and then you have the burden of proof. Okay, so the burden of proof lies on the prosecution. Burden of proof, how is it different from onus of proof? Onus of proof is to prove the whole case. Okay, whereas burden of proof is to do with just a mere single fact. So for example, you claim that, okay, I was in say Calcutta on the day of the murder. Okay, the burden of proof lies on the prosecution to prove otherwise, that you were not in Calcutta but say in Chennai that day. Okay, the onus of the proof is to determine the whole case. Understand that? Now, what are the evaluation of the facts? All of these are considered by the court before it is admitted as an evidence by the court. Okay, have a look at this slide. Again, it's little, say, heavy in judicial content, but these will frame your understanding of why we are doing what we are doing. Okay, so now that you have understood this whole 3 things, let's look at the major challenges. IPC, CrPC all have major challenges up until now. Okay, and primary among them are to do with say particular rules that have been debated, say the defamation rule or the rule on say same sex, okay, or the rule on say adultery. All of these are existing under the IPC because again they are to do with say crimes, perceived crimes committed by a particular individual. So you have the section 377, okay, the same sex relationship section of the IPC. You find that in the Navtej Johar case, the Supreme Court overturned this, albeit with limitations. So right now it has again a mixed particular status in our country. Section 377 to do with same-sex relations. Okay. At the same time, you're finding 309, which is to do with suicide. So earlier it was considered to be like a huge problem, no? That, oh, a person commits suicide, attempts suicide, fails, and then you find that the state goes ahead and prosecutes the person. Okay, this is still a problem, by the way. It's not that it has been done away with. This is still a part of the IPC. Only what you find is that the Mental Healthcare Act, okay, the Mental Healthcare Act goes ahead and mentions that, well, individuals may not be prosecuted under section 309 of the IPC because now we are looking at rehabilitation, addressing the problem that caused the person to take this extreme step of attempting suicide. Okay, but as part of the IPC, it's still there, which is why you find that it's not uniform application throughout the country. Some courts you still find that will prosecute individuals under section 309 for attempt to suicide rather than say address it as a mental health problem. Okay, then you're looking at adultery, which means that if say the notion is that if your wife goes ahead and cheats, okay, so that is again to do with section 497. If a spousal partner cheats, is it a criminal offense? Okay, because again what you find is that section 497 is often used say in terms of enforcing patriarchal values, that wife is the property of the husband is sought to be legitimized by this particular section. So again, in say the definition of the individual space of an individual, the wife or the husband, they have some individual rights. And so in spite of the fact that marriage as a social contract, if they have gone ahead and say engaged in some sort of relations with someone outside, it can't be considered to be a criminal act. Okay, so to go ahead and charge someone under IPC essentially reinforces that the modesty of that individual, the onus of or the responsibility of that lies with the other person. That's not correct. Do you understand that? Okay. You are also looking at the sedition law, which has been in the news, section 124, I believe. Okay, section 124 of the IPC. Blasphemy again. So you must understand, blasphemy is to do with say going and disrespecting a particular religion or a religious object or a religious symbol. So in a country like ours, should blasphemy have any place? Now that's a question you should consider. Again, there could be arguments for the case, against the case. I am fine with both as long as you give me proper evidence justifying your rationale, your motivation. Alright. Sexual offences under the code reveal patriarchal values, like I told you. Victorian morality, this one here, adultery. Okay. Similarly, CrPC, the criminal procedure, the procedure of trial of say conviction or exoneration, all of that is decided by the CrPC. And you find that in spite of say the various amendments that have been introduced to it from time to time, it has still failed to meet the aspirations of the people. In many number of cases, overcrowding in jails. You find that section 144, that the DC or the DM or the SDM applies. It is used almost at the personal discretion of the DC or the DM, much like without any rationale at times. Okay, again a part of the CrPC. Why? Because you are going to reinforce, you are going to restrict freedom of movement so as to carry out a particular activity. Do you realize? So all of these are problems with the CrPC. Now the problem is that most students right now will be focusing on the changes. Okay, changes proposed in yesterday's 3 bills. So for example, I'll give you a gist of few of the changes. That for the first time you will see community service being brought in India. Okay, what is community service? That you go ahead and say work with the municipality in cleaning the streets. Okay, or you go ahead and say engage in social service and in areas where the government is functioning. Okay, that you go ahead and probably go ahead and clean an educational institution on its off days. Something like that. Community service is a part of this new bill that is being proposed. Okay, you are finding a host of other changes that are being introduced. So for example, the sedition law, section 124A. Okay, that even though it has been repealed, the new Achar Sanhita, the Sanhita that talks about has section 150, which again is essentially in basis talks about the same, promoting disaffection against the government, working against the interests of the government. So is it again a old wine in a new bottle, or is it actually going to be a change that say the IPC, the CrPC requires? We'll know only in the times to come, because right now this bill is still in the nascent stage. It has gone to the standing committee. Now the procedure, the standing committee will examine it clause by clause. Each and every clause it will understand it with. The minister responsible is also a part of this. So they'll sit down together. Okay. work out, say, the changes that they want to make. Thereafter, the bill is referred to the government. The government may choose to accept the recommendations or may reject it. Thereafter, it travels from the Lok Sabha to the Rajya Sabha and finally to becoming an act. Now, please understand that the bill has been introduced in Lok Sabha, which means it has time only till next year before the announcement of the elections to pass, or else it will lapse with the dissolution of the House, the general elections being announced. Are you clear? So these are the various facets that you need to know. Because it has been introduced in Lok Sabha, the chances are that in the winter session that is to come in December, the Parliamentary Standing Committee would have done its consultations, yes, submitted its recommendations, and the government will take a call eventually. Okay. What will the Parliamentary Standing Committee do with the bill right now? Besides, say, examining it clause by clause, it will ask for recommendations. So if you go ahead to the Lok Sabha website, you will see that this afternoon it will be operationalized. As a citizen, you have the option to go ahead and submit your recommendations, changes to the IPC that you may so want. Okay. Associations, organizations of judiciary, of legal organizations are invited to give suggestions by the Parliamentary Standing Committee. This process of consultation will go on up until the winter session, after which this will most likely be passed and made into a law. Clear hai? Are you absolutely clear of, say, the Adversary System, the Inquisitorial System, IPC, CrPC, Evidence Act? If this is clear, your topic is clear now. Go ahead and read any article from Hindu, Express, wherever, PRS, FRS, clear ho jayega sab kuch. Koi tension nahi hai. Okay. So go through this. I've given you the whole lowdown of it. Okay. This first question for the day, you leave the answers for me in the comment box, by the way. Okay. First question. Substantive criminal law deals with crimes and punishment in criminal law. Correct or incorrect? We dealt with substantive versus procedural today. I explained it to you. Okay. Procedural law deals with making, administering and enforcing substantive law. Third statement, IPC is the primary legislation on procedure for administration of substantive criminal law in India. Identify the correct statements, incorrect statements. Okay. Make sure that you understand the difference between substantive and procedural, and this question you can solve in 30 seconds. 30 seconds is all it will take you. Next, cognizable offence, arrest with warrant. Non-cognizable offence, arrest without warrant. Bailable offence, bailable under existing law. Okay. Identify the incorrectly matched. Okay. What's the question, Shubhankar? I'll have to check that, Shubhankar. Can you connect with me on my Instagram? I'll check that up and let you know. Will that be okay? Okay. Alright, let's look at the third statement. India uses the common law system in delivery of justice. Indian Constitution empowers the President of India to act as the guardian of law. Is the President of India the guardian of law? And statement C, SC, Supreme Court can admit writ petitions in case of serious human rights violations or any petition filed under Article 32. Identify the correct statements. ठीक है? All right. So that completes your IPC, CrPC, Evidence Act. If you understood what I was trying to convey, go ahead and leave me a like. Okay. Because this will solidify your understanding. It has given you the fundamental basis of understanding any particular topic. And so go ahead. After you read the slides, read any article from Hindu Express. Now it will be absolutely crystal clear for you. The whole procedure that is in place, the rules, regulations, what is it all about? Okay. Subhankar, can you connect with me on my email then? Will that be fair? Or I'll let you know in tomorrow's class or Monday's class. Okay. By the way, this is the Azadi Ka Amrit Mahotsav sale that is going on. It's probably for the next 3 days only. Yes. On the 15th, this closes. On this Independence Day special, give yourself the gift of knowledge. Go ahead and make sure that you're prepared for your optional by December. Okay. So our optional batches are starting. And well, honestly, truth be told, this is the lowest ever price for this particular optional course. Okay. I have always gone ahead and informed my students of these courses. And honestly, this is the lowest so far. So this would be a good time to go ahead and sign for your optional courses. You'll be saving a lot of money. Okay. And make sure that in the payments page, you use the code BALIVE so that you get this discounted code. Okay. And if you haven't prepared your optional so far, or if you haven't decided on your optional so far, here is a piece of free advice. Get cracking on your optional. If you haven't completed, say, at least 70% of your paper 1 and say around 30-40% of your paper 2 by December, you are not giving yourself the best chance for next year. Okay. Optional scores, mains score, define the service that you will enter. Firstly selection, thereafter the service, thereafter eventually your cadre. Your next 35 years are going to be decided by your main score. Okay. So go ahead, make sure that you take your decision for your optional and get cracking at it ASAP. Okay. Alright. So we'll take a look at the Indian Eagle Owl now. Please understand least concern in the IUCN. So really in terms of say the conservation process, we are not looking at a lot of issues here. Okay. What we do find is that up until now the Indian owl was supposed to be a subspecies of the Eurasian owl. However, what you find is now that it has individual characteristics, individual habits, which is why now it has been categorized as a specific separate species. Okay. So what is happening here is it has been recognized as a distinct species from the Eurasian eagle owl. Now this is commonly seen across India. Okay. It's not something that you will find just in pockets. Okay. Across India, from the plains to say the sub-hilly areas, Indian eagle owl is commonly found. Okay. Besides say having an ecological relevance in terms of say going and acting on the rodents, the insects, the lower level, lower trophy animals, this also has a huge social and cultural relevance. Yes. So different states interpret the presence or the absence of the Indian eagle owl in a different manner. Some states it is considered to be good omen, some states bad omen. Okay. Is it the which god's vehicle is the Indian eagle owl? Which god resides or uses the Indian eagle owl as a vehicle? Can someone tell me? Huh? Let me know. It's considered to be of prosperity, by the way. You know. So what you find is that widely distributed, including India, Nepal, Sri Lanka, Pakistan. Least concern. So environmentally not much problem there. But what you find is that the females are larger in size than the males, and the males have a 2-hoot noise or a 2-pitch noise that they make. Okay. This is how you understand which is a male and a female. The male one makes a 2-frequency or a 2-hoot noise right at dusk. Okay. Or dawn in fact. Okay. And they make this noise specifically during breeding season or mating season. Correct? Good answer, Bulbul. Okay. So during mating season, you find that the particular male Indian eagle owl makes this high frequency, high pitched sound. Normally, physical dimension wise, females are larger than males. Alright. And heavily dependent on forests. In fact, it thrives anywhere, you know. It does not need say a particular tree cover or a canopy cover, or if it lives in urban areas, it will not survive, nothing like that. It's a very resilient animal. Okay. It prefers crevices or high at a height. It likes to make its nest at a height. Okay. Why again? Because it's a very nocturnal animal. It comes out only at night. So you have two types now. You have nocturnal and then you have diurnal. The diurnal one comes out only during the day, whereas the nocturnal one comes out during the night. The owls come out during the night. Okay. It has cultural importance and it contributes to pest control. Clear hai sabko? Suresh, absolutely sahi ho aap. Halesh, good morning. Good morning. All right. Let's look at this question, guys. Indian eagle owl is a diurnal species. Indian eagle owl has a distinctive ear tuft that looks like horns. You see this? This ear tuft? Yes. This looks like horns. Why again? What's the process being followed here? When say animals have these kind of physiological dimensions that make them different than what they are. What is it called? So for example, you will see a cobra. There is something right at the back of it. Why is it there? What's the function of it? Have you ever thought of it? Socha hai kabhi? What's the point of it? Huh? Next. Indian eagle owls are characterized by 2-note calls, especially by males during breeding season. Identify the correct statements. Okay, leave the answer for me in the comment box, guys. Alright. Okay, that was the Indian eagle owl. Now, finally, the 4th lecture of this has gone online. Okay. Please go ahead and answer the questions. There are around 7 to 8 MCQs. You will find this video under the live tab. Okay. Under the live tab on StudyIQ English, or the entire playlist of this is also available. The questions of lecture 4 are important. We talked about ecological succession, homeostasis, and pyramids, ecological pyramids. And I can say this with absolute certainty, UPSC has asked questions from here multiple times. Multiple times. Okay, not just say one particular year, multiple years. Which is why it is in your best interests to prepare your fundamentals at a level that is desired. Okay, go ahead and attempt the questions, leave their answers for me in the comment box. The 5th lecture of this, where we will finally close the fundamentals and finally move on to ecology, is coming next week, early next week. Okay, so please go ahead and take active part in this series also. Okay, finally, we'll take a look at Keralam. The state of Kerala has gone ahead and passed a resolution, okay, urging that the name of the state be changed from Kerala to Keralam. Okay, Keralam is obviously the Malayali way of saying it in Malayalam, all right, whereas Kerala is in native English, okay, standard English. So the Kerala State Legislative Assembly goes ahead and has asked for this request, and this resolution invokes Article 3 of the Constitution, addressing the alteration of existing state names, boundaries, areas. So straight away, it becomes important for us to go ahead and quickly revise Article 3. Okay, there's nothing else to really consider here. We have to quickly take a deep dive into Article 3. भानु प्रताप, भूगोल की आप पूछ रहे हो? ज्योग्राफी की क्लास? ज्योग्राफी की क्लास अभी मैंने चालू नहीं की है, अभी बस करंट अफेयर्स और इन्वायरमेंट कर रहे हैं. ज्योग्राफी आफ्टर वी फिनिश इन्वायरमेंट, फिर उसके बाद हम ज्योग्राफी और सीसैट का देखेंगे. ठीक है? ओके. Article 3 of the Indian Constitution, it outlines the provisions for what? First, new states. Next, alteration of areas, boundaries or names of existing states. Both. Creation of new states, whereas changing the boundary, area, name of existing states, to do with Article 3. Now let's look at Article 3 in detail. Number 1, formation of new states. How are you going to form the new states? Either you separate territory from existing states, or you unite 2 or more states, or you unite any territory with a part of existing state. Is it the only way you can form a new state here? Okay, either you break some material from an existing state, join 2 states, or have a territory that you have amalgamated with a particular state. All 3 conditions, Article 3 applies. Okay, you're also looking at altering state boundaries, changing state names, all of that to be done under Article 3, which means that this is to do with essentially what? The reorganization of states in India, that the parliament can make and break at will. That's how we know it, no? ठीक है? That the parliament can create and make and break at will. So what happens here? How is that process created? How is that process done? What you find is that this can happen only in 2 conditions. Number 1, that there is a presidential reference. Okay, that the President of India goes ahead and says that the parliament should go ahead and create a new state. Or number 2, that there is a resolution that is moved by a particular state. In this example, the Kerala example. Okay, so you have a resolution or a presidential reference. In only these 2 conditions, Article 3 straight away jumps in. ठीक है? Okay, next. So what happens? The whole procedure देखो अभी. Introduction of bill, recommendation of president or resolution of state. Only 2 conditions, guys. The bill is introduced, thereafter the bill is referred to the state. Okay. Now the state goes ahead and gives its own opinion, its own analysis. In certain cases, extension is also given to the state because again, it's a very important process that you are dealing with. So multiple extensions can be given. Okay. The president, after having sent it to the state, can give multiple extensions so as to enable the state to give an opinion. Okay, state will give an opinion. After the state has given an opinion, now what you realize is that the state's views are not binding on the president, which means the president here in fact being a synonym for the central government really. So the state's views are not binding. They may go ahead and say, okay, do this, do that, don't do this, don't do that. Eventually it's the parliament's call, it's the central government's call. Okay, why? Because again, parliament is the ultimate responsibility for India. You know, the will of the people lies there. Okay. So parliament proceeds with legislation. The input received from the affected state legislature It informs the decision making. Do you realize what's informs? It guides. It's not mandatory. It guides. Normally it is accepted. Okay. And it reflects the principles of federalism, consultation and preservation of national unity by going through this entire consultative process. Okay. This consultative process is ensuring that India's diversity, this federal structure that we often talk about, all that is taken care of. ठीक है? Clear है? चेत रामवत CSAT करो पहले. CSAT, अच्छा, I'll tell you briefly why I don't want to do CSAT right now, Chetan. Okay, because right now if I start CSAT, the recall value of CSAT right now, when you appear for examination next year, will be very less. Right now is a good time to go ahead and prepare for your mains, your static subjects. We will approach CSAT say around after Diwali Dashara. Because what happens then? Then you can carry that momentum to the examination. Right now it is too early. Okay, if you want to go ahead and start, you have my best wishes. But you will find is that the returns on the effort that you put in, you would have peaked on your CSAT by say January, February already. Or you will lose the motivation to continue at the same level for CSAT. Which is why it makes sense to go ahead and solidify one part of your preparation first. That is the static subjects. And say tackle CSAT from after Diwali Dashara. That's my plan of action. However, what I'll do is, I'll put this question up in my Telegram channel and I'll ask the will of my students. Okay. So after we finish environment, which subject should we take? If you really want to go ahead, join my Telegram channel and we'll see. The results of the students will be, the mandate of the students will be respected. Okay. All right. Okay. Let's look at this question, guys. Question number 5. Article 2 relates to the formation or changes of existing states or UTs of India. Article 3 relates to the establishment or admission of new states that are not a part of the Union of India. Article 4 empowers the Parliament to implement Article 2 and 3 with simple majority. You will answer the question for me. Identify the correct answer. Leave that for me in the comment box. And finally, the last question of this day. Police action. Where was it used? Referendum. Where was it used? An instrument of accession to chalo pata hoga aapko. Okay. Identify the correctly matched. So we have questions from 1 to 6. Please make sure that you leave all the answers for me in the comment box. And I will see that the best answers, the correct answers will be figuring in the next class. Clear hai? Alright, that completes our 3 topics for the day. Go ahead and leave me a like, guys. The like count is so low. Yeah, leave me a like. Okay, I really appreciate it. And go ahead and join this Telegram channel because the PDF of this you will find uploaded. Okay. You also have mains questions that I share here. And again, if you want to answer those mains questions, which I strongly implore you to, well, this is my email ID, bhuvan.jha@studyiq.com. Send me your answers in PDF format and I will respond to you in say around 48 to 72 hours normally. Okay? All right. Okay, guys, that's it for this day and this week. In fact, this concludes the editorial edge. Go ahead, have a fantastic weekend. More importantly, have a productive weekend. Go ahead and revise the questions that I have put forth before you in this class. Also in the Aranya series lecture 4 class. Okay. Till I see you on Monday with another set of questions, topics. Have a good weekend. Bye. See you.